I'm Daniel Mail, covering the federal trial of the Alexander brothers. Today, I want to walk you through what happened with juror number 6, who was removed from the case on February 12th, 2026. Now, I need to be upfront with you. The most important parts of the story are sealed. I myself do not know them. There's huge portions of the transcript that are simply missing and not available to the public. Those sealed sections contain the actual questioning of juror 6 and the court's decision-making process. But we can piece together what happened from the unsealed sidebar discussions between the lawyers and Judge Caproni. So here's what we know. On the morning of February 11th, something happened that caused the trial to start late. The court record shows that the jury was kept waiting while the lawyers met with Judge Valerie Caproni. When they finally brought the witness back in, Judge Caproni told the courtroom, quote, "I'm terribly sorry we kept you waiting. Trust me, we were working." What were they working on? A juror had sent a note or message to the court raising concerns about juror number 6. Later that day, during the lunch break, the lawyers came back to discuss next steps. That's when we start to see what the issue was. Defense attorney Mark Agnifilo explained the defense's position. He said, and I'm reading directly from the transcript, "My worry, and I come back to what the note said, is that the person said it in front of the group. So that's already out there. That's part of the record at this point, that this was said in front of everybody." Agnifilo was arguing that whatever juror 6 said, they said it in front of other jurors, which meant the court needed to question all of them, not just juror 6. The concern here was about premature deliberation. In another part of the sidebar discussion, Agnifilo referenced asking jurors whether they had heard, quote, "things that anyone had made up their mind or that anyone was going to refuse to deliberate or saying they would not deliberate." So the allegation was that juror 6 may have indicated they'd already decided the case before all the evidence was in. The prosecution had a different approach. Assistant U.S. Attorney Madison Smizer proposed this, quote, "Our proposal would be to talk to juror number 6 again at the end of the day, ask some of the follow-up questions we were talking about in the robing room to really zero in on whether there is the possibility that he didn't just remember this and actually did say something, and there is not any inconsistency between him and the person who emailed." End quote. Notice she said again, meaning juror 6 had already been questioned that morning. That's the sealed portion that we can't see. Smizer continued, quote, "I think if the concern is holding two people back, like we could just hold juror 6 back. We can have the next juror come in earlier in the morning if we needed to talk to that person." End quote. The government wanted to take it step by step, talk to juror 6 again, then maybe talk to the juror who wrote the note, and only question all the jurors if absolutely necessary. Judge Caproni seemed to lean toward the prosecution's approach. She said, quote, "I think I'd be inclined to talk to the person who wrote the note to try to do what you had started the day with, of trying to get greater, what's the context? You said he said it in front of everybody. Tell me what happened, and to get a better feel for that." End quote. But she acknowledged the defense might be right. She said, quote, "I think the defense may be right. I'm not sure. I think they may be right that we're eventually going to get to the point where the prudent step is to do a quick inquiry of everybody, but we're not there yet." Defense attorney Howard Strebnick pointed out a problem with trying to keep this quiet. He said, quote, "They all know juror number 6 was held back this morning." Close quote. The other jurors already knew something was going on. The court couldn't pretend nothing had happened. The judge decided to move forward with questioning the juror who wrote the note, and she planned to do it discreetly at the end of the day. She overruled the defense's objection, saying, quote, "She knows she sent us a text. She knows that this court will have to do something, so I appreciate your objection, but that objection is overruled." And that's the end of the section talking about this on February 11th. The next morning, February 12th, the lawyers were back at sidebar before. Again, that entire discussion is sealed. But later that day, Judge Caproni made a statement that tells us how it ended. She was discussing scheduling and other trial matters when she said this, quote, "My view is this is an issue where I think I've done the thing that I have to do because juror number 6 is no longer with us. And whatever the next step is, if there is a next step, we've got it time to make sure that we get it right. And I think getting it right is more important than getting it fast." So she says, juror 6 is no longer with us. That's how we know juror 6 was removed from the case. Judge didn't explain why in that moment. That explanation is presumably in the sealed portion from earlier that morning. So to sum up what we know, a juror sent a note to the court about something juror 6 said. The concern was that Juror 6 had prematurely made up their mind about the case or indicated they wouldn't deliberate fairly. Judge Caproni questioned Juror 6 on the morning of February 11th. That's sealed. She then questioned the juror who wrote the note, also sealed. And on February 12th, she removed Juror 6 from the case. An alternate juror would have taken their place, and the trial continued. The full story, the actual words spoken by Juror 6, the testimony from the concerned juror, and Judge Caproni's reasoning, all of that remains under seal. Whether those pages will ever be made public is unclear. For now, this is as much as we know about why Juror 6 is no longer part of this trial. I'm Daniel Mail, and I'll continue covering this case as it develops.